Back to In Session in Florida versus Monson. I'm Vinnie Politan. Cynthia Monson says Patricia Thomas was coming to take her kids, that Thomas felt like she deserved custodial rights for Monson's two youngest children, whom Monson adopted early on in their relationship. Now, Thomas was present for much of the kids' upbringing and developed a relationship with them, but legally, in Florida, she had no rights. Let's talk about the laws regarding gay couples and adoption. We have an expert panel assembled for you folks. In Session law enforcement contributor Mike Brooks is with us here in studio. And from New York, In Session legal contributor Midwin Charles and family law attorney Randy Kessler. All right, let's start with gay adoption. And I'll start with you, Randy. In this country right now, as we stand, how difficult is it for gay couples to adopt?
Well, in the country, it's getting easier and easier, and different states have different rules. But in Florida, it's about as hard as it is anywhere. In Florida, a gay couple cannot adopt, a gay person cannot adopt if they're engaged in homosexual activity. And the rationale is...
What do you mean homosexual activity? That means that they're having sex with someone of the same sex?
I guess you could... And
how do they find that out? What do? They have spies, or do you fill out some sort of affidavit or something?
You know, maybe it's like Justice Potter Stewart said about pornography. You know, I know it when I see it. But,
yeah, that's interesting. But that's not very. That's more of the exception rather than the rule in this country right now.
That is the exception, and it may change in Florida today, tomorrow, very soon. There's a pending case where a foster couple, two men, tried to adopt the kids that they were raising, and the trial judge said okay, and it's on appeal. And we're going to see if that law is now going to be held to be unconstitutional. The law in Florida that says you can only adopt if you are not a homosexual that's engaged in homosexual activity.
You know what, Randy, in this case, you've got 5 bullet wounds, alleged self-defense, 3 in the head, 2 in the back. That doesn't necessarily scream self-defense, does it, Randy?
No, it doesn't. And under Florida law, the fear of danger to yourself has to be imminent. There has to be an imminent threat. Is it imminent that she's going to go all the way out to her car, look for the gun, and bring it back?
Right.
And Mike also said, you know, Monson could have gotten a restraining order, but you need to know, as family lawyers, we know a lot of people should get restraining orders, but they don't because it's just a piece of paper, and you can't hold that against somebody. But Monson should have gotten a restraining order. If she knew she was going to have to protect herself, you at least take the first steps, and you try the restraining order process first before you defend yourself lethally.